Dear students, I welcome you to yet another lecture on corporate law. The topic of discussion for today's lecture is the position and powers of directors. The objectives of today's lecture are: number 1, to understand the position of directors; number 2, to understand the position of directors as agents; number 3, to understand the position of directors as trustees; number 4, to understand the position of directors as organs; number 5, to understand the powers of directors; number 6, to understand the powers of directors which can be exercised only by means of resolutions passed at the meeting of the board; and lastly, to understand the powers of the directors which can be exercised only in the general meeting. Dear students, we shall first and foremost discuss the position of directors. A company is an artificial person having existence only in the contemplation of law, and as such it cannot act in its own person. Therefore, there must be some human agency to carry on the company's business. Commenting on this, Lord Justice Viscount Haldane in Leonard's Carrying Company Limited versus Asiatic Petroleum Company Limited observed, and I quote, "A corporation is an abstraction. It has no mind of its own any more than it has a body of its own. Its active and directive will must consequently be sought in the person of somebody who for some purposes may be called an agent, but who is really the directing mind and will of the corporation, the very ego and center of personality of the corporation." Unquote. The invisible and intangible nature of a company makes it obligatory for this corporate body to appoint some living person or persons through whom it may act and carry on its business. Such persons are usually called directors of the company. Section 2, Clause 34 of the Companies Act 2013 defines the term director as any person appointed to the board of the company. The directors of a public company need not necessarily be experts in the type of a business which the company is promoting. A company's board of directors may, however, consist of persons specialized in different branches of business administration such as accounts, finance, law, banking, management, etc., including a few experts in the field of the company's business. Thus, it was pointed out in Re City Equitable Fire Insurance Company that a director of a life insurance company does not guarantee that he has the skill of an actuary or a physician. A company, being a creature of law, lacks both mind and body. Unlike a natural person, it cannot act by itself. It is intangible and indivisible, but functions through the complex mechanism of human agency. At the helm of its affairs lie a few elected human agents who govern the company under the title directors. As an invisible hand, a company merely reigns through its formal seal. It is therefore necessary for every company to have certain directors for its administration and management. The position of directors is not defined in the statute itself. Section 2, Clause 34 of the Companies Act 2013 simply defines the director to include any person occupying the position of a director by whatever name called. Consequent upon the silence of the Companies Act 2013, the judiciary has supplied various opinions to fill this gap. Sometimes the directors are described to hold the position as agents for the company, sometimes as managing partners of a company, and sometimes as trustees of the company. These descriptions of directors are significant only when the position of a director is studied from different angles in relation to a particular instance. It is for this reason that Lord Justice Bowen has made a very important observation in the case of Imperial Hydropathic Hotel Company versus Hampson, to dispel any doubt as to the true position of directors. He said, and I quote, "Directors are sometimes described as agents, sometimes as trustees, and sometimes as managing partners. But each of these expressions is used not as exhaustive of their powers and responsibilities, but as indicating useful points of view from which they may for the moment and for the particular purpose be considered." unquote. Dear students, now let us attempt to assess the position of a director of a company from different angles. First and foremost, we discuss the position of directors as agents. Directors are primarily recognized as agents of the company. Since the company cannot act of its own accord by reason of its artificial character, it acts through human agency like directors. In the classical case of Ferguson versus Wilson, Lord Justice Keynes observed that the directors are merely agents of the company. There exists principal and agent relationship between a company and a director insofar as a director acts within the terms expressly provided for this purpose. A notice to a director will amount to a notice to the company. But there is a fetter on the knowledge of a director to be the knowledge of the company. A notice received by a director in his personal capacity will not be regarded as a notice received by him in his capacity as a director. This is evident from the decision of Re Hampshire Land Company, where the knowledge of a person as a director of one company was not held to be an imputed notice of that person as a director of another company. We now discuss some illustrations. In Sardar Gulab Singh versus Punjab Zamindar Bank Limited, the division bench of the Lahore High Court has held that a director or a managing director is in no way a servant of the company. He is the agent of the company for carrying on its business. In R.K. Dalmia versus Delhi Administration, the court observed that directors are agents and also trustees in respect of the property over which they have domain in the course of their duties as agents. Dear students, we shall now discuss the position of directors as trustees. A trustee is a person who holds property in trust for another. How far the proposition that directors hold property in trust for a company is correct requires serious consideration. In Charitable Corporation versus Sutton, the directors of a chartered corporation were held liable as trustees for breach of trust. Similarly, in a number of English and Indian cases, the directors were construed to be the trustees in relation to a company. The directors are not trustees for each and every act of omission for which they are responsible. They are mainly confined to certain matters. In other matters, they may be deemed to be the agents of the company. Lord Selborne has drawn a line of demarcation in this regard in Great Eastern Railway Company versus Turner. He said, and I quote, "The directors are the mere trustees or agents of the company, the trustees of a company's money and property, agents in transactions which they enter into on behalf of the company," unquote. The directors are liable as trustees for anything done which is inconsistent with the authority of the directors laid down either in express terms or by implication in dealing with the company's money and property. In addition, they also act as trustees in exercising the powers conferred on them by the Articles of Association, as for example, the power of approving transfer of shares, allotment of shares, making calls on shares, and the power of forfeiture of shares fall in this category. The directors are trustees for the company and not for any individual shareholder of the company. This principle was firmly established in Percival versus Wright. In this case, the directors were not held liable to a shareholder for purchase of his shares without disclosing certain facts to him. But the directors could be held liable if they would induce the shareholder to sell his shares. In the former, mere silence as to the fact by one of the parties has not vitiated the contract. On the other hand, in the latter case, element of fraud is present. But it is submitted that this view is not tenable on one ground. A shareholder, being a part of the company, deserves communication from those executives or insiders who conduct closed-door negotiation in which his interest is deeply involved. For that reason, a transaction between a shareholder and a director of that company should be placed on the footing of a contract of uberrima fides. Dear students, we shall look at certain illustrations now. In V.R. Ramaswamy Iyer versus Brahmaya and Company, the division bench of the Madras High Court has held that the directors of a company are trustees for the company and not for the individual shareholders thereof. They can be rendered liable as trustees for misuse of their power and fund of the company, and on their death the cause of action survives against their legal representatives. Another illustration is on the profits made by directors. In Bath versus Standard Land Company Limited, by an agreement, a company arranged with the plaintiff to manage, develop and realize his estate on certain terms as a remuneration. In the course of such management, two directors acted professionally for the estate. It was held that the directors stood in a fiduciary relation to the company and not to the plaintiff, and thus the costs, the profit, salary and commission paid to the directors in their professional capacity might be allowed in taxing the accounts between the plaintiff and the company under the agreement. Another illustration would be benefit of contracts to directors. In Cook versus Deeks, it was held that the directors of a company are not at a liberty to divert in their own individual favour business which should properly belong to the company of which they are directors, but must be regarded as holding the benefit of such contract on behalf of the company. In Sangram Singh Gaikwad versus Shanti Devi P. Gaikwad, it was been held by the Supreme Court that the director of a company indisputably stands in a fiduciary capacity vis-a-vis the company. He must act for the paramount interest of the company. He does not have any statutory duty to perform so far as the individual shareholders are concerned, subject of course to any special arrangement which may be entered into in a particular case. The directors do not have any fiduciary duty to advise the shareholders. In case of conflict of interest between the company and the fiduciary duty towards the shareholders, the former shall prevail over the latter. Dear students, we now discuss the position of directors as quasi-trustees. Directors are not in the true sense trustees of a company. There are a number of differences between the position of a director and that of a trustee. First, a trustee holds property in his own name subject to the equitable obligation of cestui trust, but the director never holds the company's property in his own name. In other words, a trustee deals with the trust property as a principal, as an owner, as a master, whereas a director is a paid servant of the company. A trustee can enter into a contract in his own name, but a director can do so only under the seal of the company. Secondly, the position of a trustee is a creation of equity, but the position of a director is recognition of the common law in England. Thirdly, a trustee is entitled to mix up the trust fund with his own, and in that case certain principles of drawing are followed. So far as a director is concerned, he is not authorized by law to mix up the company fund or property with his own. Justice Romer in Rees City Equitable Fire Insurance Company has vigorously objected to draw an analogy between the position of directors and that of trustees. He observes, and I quote, "I can see but little resemblance between the duties of a director and the duties of a trust, of a will or of a marriage settlement. It is indeed impossible to describe the duties of directors in general terms, whether by mere analogy or otherwise." Unquote. So, the directors are not trustees in the real sense of the word, but they can be described as quasi-trustees in some respect. Dear students, we now discuss the position of directors as managing partners. The analogy of a director with a managing partner is mainly based on partnership principle. A director, for like a partner, must hold interest in the company. Like a managing partner, a director is authorized to manage the affairs of the company in which other shareholders are compared to dormant or inactive partners. But this analogy is misleading. It does not cover the true position of a director. In the case of a partnership, the partners, by a decision, confer benefit on third party, But in Re Newman and Company, an agreement to confer benefit on the widow of a director was held ultra vires the company, since that was neither incidental to nor beneficial for the company. Dear students, we now discuss the position of directors as organs of the company. A company has no physical existence. It is just an abstraction of law. It operates through the board of directors, who are known to be the brains and the only brain of the company. So anything done by the directors in course of office and within the scope of their duties is deemed to be an act of the company. The company is entitled to the benefit or liable to compensation that is arising out of the transaction made between the directors on behalf of the company and a third party. The directors thus represent the organs of a company. This has facilitated the work of the court. By application of the organic doctrine, the court draws a close relation between the company and the directors. Thus, it is important to remember that the company has no mind of its own. It can only operate through the artificial mind of the human brain. Directors constitute this brain of the company. So, on the basis of the usual practice, a company stands as the respondent superior of the directors in relation to third parties. The company is liable for the action of the board of directors because its action is the very action of the company. But this analogy of directors with an organ is also defective. Unlike an organ, a director is not a part and parcel of the company body. One is a creature of nature and the other is a creature of law. Directors are liable independently of the company for breach of statutory duty, but an organ does not suffer from any illness without its immediate effect on the whole body. Besides this, the controlling voice of the government, the legislature, the executive and the judiciary put brakes occasionally on the functions of the directors. They retain their office subject to the satisfaction of the shareholders, the central government and the court. So they cannot in fact act like the human brain to prove their worth. It is not correct to describe the position of a director completely with any other office. In fact, a director combines the varied offices, and any particular analogy to cover all his functions is utterly misleading. A director is neither a trustee, nor an agent, nor a managing partner, nor an organ of the company, but a combination of all and something else, which is the peculiar characteristic of this office. The powers and duties of the directors are mutually coextensive, and one cannot exist without the other. Though these are correlated, they deserve separate consideration. We now discuss the powers of the directors. A company is an artificial person which acts through its directors. The directors are considered to be the pilots of a company. They do not have absolute power to drive the company in any direction they like. They have to follow the codes or the principles of law to guide the company. The powers of the directors can be broadly divided into certain categories. The first category would be the general powers of the board. The general powers of the board of directors have been laid down in section 179 of the Companies Act 2013. By this, the board is empowered to exercise all such powers and to do all such acts and things as the company is authorized to exercise and do, subject to the provisions of the Companies Act. But these powers are restricted in several ways. First, the board cannot do anything which the company itself cannot do. The directors, being the agents of the company, cannot exercise such powers which the company as a principle is forbidden to do, either by the existing law or by the Memorandum of Association or the Articles of Association. Secondly, the board is not competent to do what the Act, the Memorandum and the Articles require to be done by the shareholders at the general meeting. Thirdly, the board cannot exceed the powers which are delegated to it by the company. In such a case, the powers exercised by the board in excess will be considered to be ultra vires. But if the act done by the board are ultra vires, the powers of the board, but intra vires the company, the latter may ratify them at the general meeting. When the company does not ratify those excessive acts of the board, the directors are liable to the third party for abusing their authority. However, it is important to remember that when the articles confer certain powers on the directors, the shareholders generally cannot intervene in the exercise of such powers by the directors. Lord Justice George Farewell has observed in this regard, and I quote, "Even a resolution of a numerical majority at a general meeting cannot impose its will upon the directors when the articles have conferred on them the control of the company's affairs." Unquote. If the shareholders do not approve the acts of the director, the remedies in such case are either to alter the articles according to the procedure or to refuse to re-elect the directors of whose actions they disapprove. It is to be noted that the directors do not enjoy absolute powers under the authority of the articles. Their powers are subject to control by the shareholders at the general meeting. In the cases we shall now discuss, the general meeting of the shareholders is competent to act even in a matter delegated to the board. The first is mala fide. The majority of the shareholders have the right to interfere and control the actions of the directors in the interest of the company. In other words, when the action of the directors is motivated or mala fide, the shareholders may interfere or control it in the general meeting. The second is board is incompetent to act. The majority of the shareholders may exercise a power vested in the board when, for some reason, the directors themselves are incompetent to act. This would happen when, for example, all the directors would be interested in the transaction. In B. N. Vishwanathan versus Tiffins Barriott Asbestos, under the provisions of the articles, the power to fill the casual vacancies was delegated to the board of directors. However, the appointment made by the shareholders in the general meeting was held to be valid because at the material time, none of the directors was validly in office. The third situation is deadlock. When the directors are unwilling to act or cannot act under the authority of the articles due to a deadlock and the administration stands still, the shareholders can act in the general meeting. In Barron versus Potter, there were only 2 directors on the board of a company. Both the directors were at loggerheads with each other. There was complete deadlock in the administration of the company due to the conflict between the existing directors. There was no provision in the articles to increase the number of directors. However, it was held that in order to ensure the working of the company had the inherent power to appoint additional directors. Dear students, we shall now discuss the powers of the board which are to be exercised only at the board's meeting. The board of directors of a company shall exercise certain powers on behalf of the company, and it shall only do so by means of resolutions passed at the meeting of the board. These are: number 1, the power to make calls on the shareholders in respect of the money unpaid on their shares. Number 2, the power to authorize the buyback of the company's own securities. Number 3, the power to issue debentures. Number 4, the power to borrow money. Number 5, the power to invest the funds of the company. Number 6, the power to make loans. The board may, by a resolution passed at its meeting, delegates its certain power to any committee of directors, the managing directors, the manager, or any other principal officer of the company. But the board cannot delegate the power to make calls and to authorize the buyback of its shares. Dear students, we now discuss the power of the board of directors, which is to be exercised only in the general meeting. The powers of the board of directors in certain cases cannot be exercised except with the consent of the company at a general meeting, that is, with the consent of the shareholders. If a decision is adopted by a numerical majority of the shareholders at a general meeting, that cannot be questioned by the minority shareholders when that decision authorizes the board to put it into effect, unless that action is a fraud on the minority shareholders or the majority shareholders have abused their powers and deprived the minority of their legitimate rights. In such cases, the liability is mainly those of the majority shareholders and not of the board of directors in particular, for the board derives its authority from the general meeting of the company. The board of directors of a public company or of a private company which is subsidiary to a public company cannot exercise powers in respect of certain matters without the consent of the company concerned in the general meeting. These are: number 1, to sell, lease or otherwise dispose of the whole or substantially the whole of the undertaking of the company. Number 2, remittance or giving time for the repayment of any debt due by a director, but no such authority is necessary for renewal or continuance of an advance made by a banking company to its directors in the ordinary course of business. Number 3, investment, otherwise then in trust securities, the sale proceeds resulting from an acquisition without the consent of the company of any property or undertaking of the company. Another power would be borrowing in excess of the aggregate paid-up share capital of the company together with its free reserves apart from the temporary loans obtained from the company's bankers in the ordinary course of business. This provision does not apply to the raising of capital by the issue of shares. The acceptance of deposits of money from the public by a banking company in the ordinary course of business does not mean borrowing within the meaning of this provision. Dear students, this was all with regard to today's lecture. In today's lecture, we tried to understand the position of directors in a company. We tried to understand the position of directors as agents of the company, as organs of the company, as trustees of the company. We also tried to understand the powers of the directors. Hope you have been able to understand the position and powers of directors. With this, we come to an end of today's lecture. Stay blessed.